Hey folks, James Abrenio coming to you here, and I have a very interesting person to interview for you. Delegate Simon, Marcus Simon, who's a good friend of mine. Just by way of introduction, he is a member of the House of Delegates, 13th district, and that includes Falls Church and part of Fairfax. And Delegate Simon, just so people know that don't aren't involved in politics, don't really vote all that much. Tell them the kind of landmarks that could help them understand, are you actually representing them, and when they should get out to vote for you? Where should they be looking towards?
Gotcha. I like the way you do that. Like, don't tell us your
Yeah.
district number because nobody knows what that means,
Yeah,
right?
yeah,
So
yeah,
give them a description of the district. So yeah,
yeah,
if you live in the city of Falls Church, or you have a Falls Church mailing address in Fairfax County, then I'm probably your delegate. So my district is it's bounded on so it's got the city of Falls Church, a couple of precincts north of that, and then it goes south down through Lake Barcroft, with Arlington County being sort of the eastern boundary and Gallows Road being sort of the western boundary. And so it's a pretty compact district.
uh-huh.
You and I served together on the redistricting
Yeah,
commission, so you know those boundaries probably pretty well. Obviously, we didn't draw these districts; the Supreme Court ended up doing
yeah,
it. We did lobby for a Falls Church district. The special masters at the Supreme Court asked for public input, and so we kind of flooded the zone with Falls Church people that wanted to keep me as their delegate.
yeah.
So at any rate, yeah, it's mostly a Falls Church district.
Yeah, and I don't mean to gush on you, but I'm a big fan. And just so people know, you've been in the General Assembly since 2013. You're on a good amount of good committees: courts of justice, public safety, communication, tech, innovation. Looks like NYU graduate, JD from American University in '99. I didn't know this. You actually served in the JAG Corps. Tell me about that. Let's talk a little about that. Like, what was that experience
Yeah.
like?
So
Yeah,
the my first job out of law school was as an Army JAG officer. I interviewed with the Alexandria Commonwealth Attorney's Office. I interviewed the Fairfax Commonwealth Attorney's Office. Yeah, I went to law school with the idea that I wanted to be a trial attorney. My view of it was, nobody goes to pilot school to fly cargo planes. You go to pilot school to fly fighter pilot, be a fighter pilot and fly the jets.
yeah,
And so I figured that's what law school was about. And generally speaking, the idea was, hey, get in there. And one of the things that the Army offered was at least they promised us this, right? Everybody was just saying in the Army, that my recruiter lied. Everybody says that, right? But the recruiter from the JAG said, look, the deal with this is you can get in and it's a meritocracy, right? You
yeah.
show us what you're able to do. We'll give you as much responsibility as we think you can handle. And so sure enough, I did legal assistance work for about 6 months. Then they sent me off to train as a prosecutor. And I was trying felony equivalent cases on my own as a first chair within about a year of graduating from law school, maybe a year and a half from graduating from law school. So it was a great opportunity for me. I enjoyed it. I served in the DC area. Mostly my wife, was a civilian and she had a job in the DC area. So it actually worked out that she could keep her job, didn't have to move across the country. I worked at Fort Myer and Fort McNair. And I really enjoyed that. I enjoyed it, but it was also a stressful lifestyle. And one of the things I learned about criminal law is, for me at any rate, and people talk about having to develop this crust as a criminal law attorney. I had a hard time building my crust. And so I took it home with me. I had sleepless nights worried about things, worried about the outcome of cases. I also found that if you're doing a good job as a prosecutor, everybody's mad at you.
Yeah,
I mean, they say the job is to do justice, right? Which means frequently the victim doesn't feel like you went hard enough after the accused. The accused family feels like you were too hard on them. The commands, like, couldn't you have gotten some more time?
yeah.
And then the defense attorney's like, why were you such a jerk the whole time? So I always found the end of the case, I didn't feel great about it. So I decided to take I didn't necessarily want a career in that, but I'm glad I had those couple 3 years and got that experience under my belt as a young attorney.
Well, I'll tell you, when I graduated in 2008, and it looked like that's when you started your own company. But I considered JAG, and I'll be honest, I didn't have the guts to do it. I'm like, I'm going to get deployed somewhere, and I can barely take care of myself and do my own laundry. So, hats off to you for taking the risk. And I will say I do criminal defense now, but I represent a lot of victims, and seeing it from that side, I do think it is harder if you're doing the prosecutor's job correctly. It is a much more emotionally fraught circumstance because you have justice on your back. Whereas if you're a defense attorney, your goal is just to mitigate or win. So I appreciate that. So thank you for your service, and that's pretty good. Pretty good experience as a trial attorney. So
One more thing,
yeah,
it's a little bit of an aside.
yeah.
I get young people all the time. They're thinking about going to law school, and one of the questions I ask them is why they think they'd be a good lawyer. And the answer I like the least is, well, I like to argue, right? And everybody says I like to argue, and so yeah, I'm going to be a good attorney. I'm like, most of being a lawyer is actually solving arguments, right?
Yeah.
I mean, arguing for the sake of arguing, and when it's academic, can be kind of fun, but when people's lives are on the line and their freedom and their livelihoods, these conversations are a lot more difficult. One of the things I didn't love about criminal, every time I picked up the phone, it was a fight, right? It was an argument, it was a fight, but it wasn't, like I said, it wasn't just like winning wasn't necessarily the goal. The goal is to try and do the right thing. So I always discourage people. If you think your reason for being a lawyer is because you like to argue, lawyers are really about solving problems, not arguing.
Yeah. And as a guy who likes trying cases, I absolutely agree with that. It's fun in court. That's fun. But at the end of the day, you got somebody's life on the line, and a lot of people looking at it. And so, but anyway, so I appreciate you coming on. The reason I want to talk to you today, and people watching this a lot of times are young lawyers looking for what they should be doing. And as a trial attorney, I always find it's important, especially at the local and state level, that lawyers be aware of what's going on around them. And I think your elected officials are so important. And so I appreciate the work that you're doing. The goal here today, if at all possible, is to try to make this as nonpartisan, as bipartisan as possible. But I'll probably get into it just as much, if not more than you. I'm probably a less tactful Democrat than you are. But the goal here is really to talk about your efforts this year and kind of just from an educational standpoint, understanding. I'm hoping people kind of understand how the sausage is made a little bit, maybe give them some tools how to better articulate to you and to other elected officials. So we do criminal defense, civil here. It looks like you're all over the board as far as paying attention to that. I love it. So what I wanted to do was focus first on criminal bills that I thought were interesting that you'd worked on, and then civil, and then we'll kind of just go from there. But the first one on the criminal side, it looks like it got vetoed, is the using essentially jury sentencing. And so the bill, as you know, HB 63, the goal was to allow the accused to withdraw jury sentencing up until literally sentencing phase. Tell me how you kind of came to know this issue, because that's a very technical criminal issue. I know you've been doing a lot of criminal justice reform. Tell me how you identified that issue and what got you interested in it.
Sure. Well, so like a lot of things, some advocates came to me with it, right? And so there's a group called Justice Forward, which is a group of attorneys, some public defenders, some defense attorneys, and some activists who are just interested in these issues. And they had a problem, which was they had this. So we actually didn't have jury sentencing at all. We didn't have a sentencing option in Virginia until about 2 years ago, right? So it used to be you had to pick between a judge trial or a jury trial. If you waived jury trial, the judge did everything. They tried you and they sentenced you. If you elected a jury trial, that meant you had to stick with the jury all the way through sentencing. And so we had a bill a couple of years ago that says, hey, you can bifurcate that, right? You can split. You can have a jury determine your guilt or innocence, but then have a judge sentence you. But like a lot of things, you have that right, but there are certain notice requirements that you've got to give to the prosecution so that they can prepare properly for trial. And so you had to let the prosecutor know, hey, I want a jury trial, but I think I'm going to want to do judge sentencing. He had, I think 30 days out, you had to let them know. And then the question was whether you could change your mind or not. And so about half of the circuits, that was a half, but in a number of circuits, the judges were like, look, you have a right to be tried, to be sentenced by the jury, right? That's your fundamental right, but you can waive that right to be sentenced by the jury at any time, just like you can waive your right against self-incrimination up to any point, but you can change your mind about that too. And so, but some others were saying, no, that's a hard and fast rule. Once you've given your notice, it's irrevocable. So what this bill aimed to do was just to clarify that what the General Assembly meant was that it should be up to the defendant, right? It's their right to waive, the right to be sentenced by a jury, and they can do that at any point, in the process, right up until sentencing, and for a number of reasons. Like sometimes you don't know what is in your best interest because you don't know what you're going to be found guilty of yet, right? You know what you're charged with, you know what your theory of the case might be, but given different mandatory minimums, given different maximums, the risk, your risk profile in sentencing might change. The other real thing that you want to do, frankly, I mean, because we're amongst lawyers here, is it gives the defense an opportunity to introduce the potential range of sentences on voir dire to the jurors, right? And so, so one approach would be just say, hey, just allow that, right? Let's just allow us to talk about, hey, would it change your mind if you knew that this person would be sentenced to a minimum of 5 years in prison if they're found guilty and things like that. So those were sort of the two things that the bill aimed to do in a couple different ways. And it's not a partisan issue. In fact, it's interestingly in the House right now, most of our criminal defense attorney members are on the Republican side of the aisle. We don't have a lot of folks that actually practice criminal law on the House side. And it picked up, it had bipartisan support in both houses. And again, it had to do a lot more with the practitioners that sort of understood the issue than partisanship. But ultimately, the governor, the VACA, the Virginia Association of Commonwealth's Attorneys, so that's another advocacy group that's out there. And the Commonwealth's attorneys are very active with the legislature, right? In trying to shape the law that they have to practice and have a role in writing it and creating it, and also playing defense as far as they were concerned on this issue. So, and the governor ultimately sided with VACA, which tends to lean more Republican and be on the more conservative side of it.
Yeah, and just to back up, I think that's how we initially met. So I used to be on the board of Justice Forward Virginia. At that point, it was such a new, or I don't know if we call it a board, but I think I'd met you at a couple of events. So for anybody paying attention, that's a great organization. Were you involved in the initial change in the law to where it allowed for judicial sentencing despite choosing a jury trial? I know you were in the legislature, obviously. Were you part of that?
I was in the legislature. I'm on the courts committee. So to the extent that it ran through the courts committee, I was. And I was part of the debate. I mean, we had a big internal debate amongst Democrats. We actually have some current, at the time, I think we had a current assistant Commonwealth's attorney in our caucus, and we had some former Commonwealth's attorneys. So oddly enough, like I said, it doesn't necessarily break down on a bipartisan basis. And the Commonwealth's attorneys were, concerned. A lot of it was a judicial economy kind of a concern, right? They were worried that, well, now there's no disincentive to pick the jury. Everybody's going to be on a jury trial, which I'm like, well, that's wait a second. So you're making the other argument. You're telling me that people who really would like to have a jury trial and want that right aren't exercising it because you guys are stacking charges and potential sentences in a way that sort of forces them to waive a fundamental right. So at any rate, but yeah, we did have some conversation about that. I was part of getting that done at the beginning.
Yeah, well, and it's interesting because prior to the change, from a practical standpoint, what the law allowed was anybody could demand a jury, but it was also jury sentencing. And what Commonwealth attorneys would generally do is if they knew a jury would slam somebody, they would demand a jury. And so that would oftentimes compel an accused to plead because they know they're going to get slammed by a jury. I don't really understand the judicial economy argument against this bill. And we're talking about the aspect of being able to withdraw your jury sentencing, because to me, what ends up happening is if a jury sentences, the jury imposes their sentence, and then the judge ultimately has to do a separate sentencing to approve of that. If you're saying judicial economy and allowing the accused to withdraw that jury sentence, that actually makes it easier because the judge is going to be doing what they're going to do anyway. So is there anything more substantive than just saying it's not judicially economic?
No, so to be clear, the initial, the initial bill, I was talking more about the initial bill of allowing.
Oh yeah.
To choose more jury sentences would be, or jury trials.
Yes, yes.
The other issue that the Commonwealth's attorneys made on this one was it forced them to prepare for two possible outcomes, right? And that was
Okay.
more of a resources issue for them, right? That
Okay.
everybody would say, yes, I'm going to have jury sentencing, and then you had to prepare witnesses for that, and you had to prep them more, and you had to prepare. It's a much different and more intensive preparation for a sentencing in front of a jury than it will be in front of a judge. And then at the last minute, you'd say, I want a judge sentencing. All that work would have been for nothing. I didn't particularly buy that argument either.
Yeah.
I mean, people prepare for trial all the time and get lots of deals.
Yeah.
I didn't find that terribly persuasive.
I mean, I'm going to deprive an accused of their right to a full jury trial because I don't want to have to do my homework at night. I don't think is really the way to get there, but they make the arguments they make. Now, what was their push against the ability during voir dire to ask about sentencing ranges?
Well, again, their view is, and Brian Porter sort of articulated this during the first hearing on it. He's a Democrat from Alexandria again. So just in your effort to be nonpartisan about this.
Yeah.
His view is that,
and he's a good prosecutor, by the way. So, but
his view is it's simply irrelevant to the guilt or innocence, to whether the person did or didn't do it. It's a ploy to try and engage. It's sort of jury nullification bait, I guess, for lack of a better way of explaining. Right? It's encouraging the jury to say, hey, I think this guy probably is guilty beyond a reasonable doubt, but I'm going to find him not guilty, not because I don't think he did it, but because I don't like what the outcome of a guilty verdict would be. And so his view is that getting that information into voir dire is not is irrelevant to the actual guilt or innocence. And that we legislators, right? His argument, and again, I get it, given his audience, say, hey, you guys decide whether these things have mandatory minimum. You decide what the sentences should be. Yeah. Don't let the jurors decide that. Their one job is supposed to decide guilt or innocence first. Yeah. Then what the sentence should be. So that was sort of the argument against that. I mean, it made sense. I didn't agree with it, but it made sense.
I mean, from a legal aspect, I understand the argument intellectually, but when you have especially mandatory minimum cases where you are essentially going to take away the jury's ability to impose what they think is right, to not allow and this isn't even the trial. This is voir dire. It's not like you're actually hearing evidence, but you're just talking about what is the world that we're going to be talking about here as far as the charges against the accused. I don't buy that, but again, I understand the intellectual argument. But let me ask you this: what's your thoughts going forward about this making headway in the future? Do you think that's going anywhere, or are you going to keep pushing it?
Yeah, no, I mean, I think so. I don't know if we'll do it again next year. I mean, given the governor's vetoed it once, I mean, unless he didn't seem to indicate that there was some room to discuss it, right? It wasn't like sort of on a narrow issue that we could try and tweak with some different language. Yeah. But I do think that it's something we need to get done and would bring it back after an election in 2025 when we have a different governor. And there may be some middle ground. I'm always open to listening. If somebody has an idea for, how, some sort of notice requirement that's reasonable, but allows you to change your mind, maybe not right up to the after the guilt or innocence phase, but I think probably I like it the way it is. I just need a better, more receptive governor.
Yeah. And I was going to ask this later on, but two questions come from that. Number one is, for the public watching this, assuming, the 5 people decide they want to do something about it. How is a legislature, how would you recommend the average Joe, the average Jane to say, you know what, Marcus, I got a good idea. I think change needs to be made. How do I get that done? How would you recommend folks approach you persuasively, logistically? What would you just say for the average person?
Yeah, I mean, so I get things from all kinds of different directions. I think that, it can be as simple as, hey, I've had this experience with state government, and I'm told that the reason it turned out the way it did is because of this quirk with the code. And are you interested in helping me fix it? Right. And I've had that problem with DMV. I can't get my, car registered from overseas until it's translated and whatever it is. And hey, can you streamline that process for me? Because we have a lot of people that move back and forth from overseas. They bring their car, right? And that can just be a person saying, hey, I've identified this problem. Everybody at the agency tells me that it's a code problem. I'm like, that's great. That's my job, right? I can fix the code. They can't fix the code, but I can do that. I do think that on bigger issues, find out if other people are experiencing your problem. So is it a one-off, or is this something that has broader concerns? And then are there other people like there that they're sort of similarly situated that are willing to sort of band together? I mean, I think that's one of the things that you talked about being an early board member with Justice Forward. But the prosecutor's side was always sort of organized. They had built-in institutions, right? They got together and they had an advocacy arm. And so I think when defense attorneys said, hey, why don't we get together? We're all encountering the same problems, the same issues over and over and over again. Let's work together collectively. So see if there's an organization out there that shares your concern or works on issues related to yours. Bring it to them and through them, and bring some allies. That helps you get a lot further, a lot faster. If you can do it that way. So and there are Justice Forward's criminal defense, but there are coalitions for family law attorneys, right? And again, I'll get a particular family law issue. I had one a few years ago. One of my early bills was, fixing our reciprocity statute so that we could get our powers of attorney, verbal powers of attorney from Pennsylvania recognized in Virginia. We had it all worked out with Maryland, West Virginia, Tennessee, whatever, but Pennsylvania is sort of one state removed, and so we needed to add them to a compact. And so as a piece of legislation, we did. So that can work with a one-off, but if there are bigger problems, there's a coalition of family law attorneys, estate planning attorneys, and so forth. So get involved in the bar, get involved in those affinity groups, find out if there's somebody else or group that represents your field, and sell them first. And that's the other thing, is sell them first, because otherwise you think you've got a great idea. And this happens a lot, frankly, in the family law context. You've got what you think is a problem in your particular case. And it turns out that although that outcome seems unjust with your particular client, it's a really good reason that it works out that way. And that if we changed it the way you want to, it would have all these unintended consequences in 90% of other cases. We have a lot of people that wind up with a legislator in a one-off bill, and I spend a lot of time in civil cell having to, unfortunately, very gently kill those bills because of the unintended consequences. So, figure out if there's a group that can help you understand. And then sometimes there's a better way to solve the problem when you start talking to other people about it. I know it's a long-winded answer, but.
No, it's great. And I'll say again, Justice Forward of Virginia, not to keep plugging them, and I don't want to take credit, because Brad Haywood, Andy Elders, Brian Kennedy, there's a lot of great public defenders. They were doing that in their private world. They wasn't part of the public defender system. They just chose to push things forward, and legislators like you now know their name well, and that's pretty amazing. On the civil side, I'm not doing this as part of the Virginia Trial Lawyers Association. This is just my own private interview, but I'm VTLA, and part of the reason is they move a lot of things and they get a lot of attention. So that's great advice. So I appreciate that. The other thing I'll say, and not to just keep plugging you, but if you find a legislator like Delegate Simon and you support them, give them money. Dollars go a long way, and it matters. And you may not have 10 hours to devote to going down to Richmond, but if you got a few $100s, maybe even more, think about that. So the other question I had, and it comes to Youngkin's vetoes, and I know you're like one of the top ringers for getting vetoes. I think that's kind of a sign of a badge of honor in a lot of ways. Not good for Virginia, but for you putting it forward, it shows what you're willing to do. Did you expect the number of vetoes, and in the situation where it just appears like there was almost a lack of communication? That's where I'm coming down with Youngkin's efforts. It's like it's almost like he didn't really even put the legs out to try to discuss these things with you. It just seemed like there was vetoes after vetoes. And I think I'm relatively well educated about the situation. Is that completely off? What would you recommend? Let's say Youngkin is watching this. What would you recommend for him to do if he's trying to get people on board, if he's trying to be more persuasive, and how maybe more agreements can be met?
Yeah, so I mean, it's interesting. I'm not surprised that there were going to be a large number of vetoes.
Yeah.
And there are a couple different categories. The way I describe this, there are certain bills that we wanted him to veto, right? We sent it to him, and we knew he would veto it, and bills that he wanted to veto, right? So sometimes they were the same, right? Hey, I'm going to send you a bill on one of the bills, gun violence prevention bill that you said,
Yeah.
hey, look, we don't want people open carrying assault weapons anywhere in Virginia. Certain localities can ban it now. We think that should be the case all over the Commonwealth. I knew he was going to veto that. I wanted to be able to go to my constituency, look how unreasonable he is. He wants to be able to go to his base and say, hey, look, I'm protecting you all and your Second Amendment rights. So that was sort of a win-win kind of veto for us.
Yeah.
Then there are also some bills that we wanted to send him that we hoped he wouldn't veto because we wanted it was good policy and we wanted it to have happen. But we were okay if he did because we thought it was a good political wedge where he didn't want to veto, right? We wanted to give him some bills that he probably had to veto for his political reasons, but he probably didn't want to. A lot of those were on the abortion issues and choice. You had an extradition bill, bill that says, hey, governor will not cooperate with Tennessee and Alabama and Texas. They want to extradite Virginia doctors who perform perfectly legal abortion services on Tennessee or Texas residents, but in Virginia. And the governor vetoed that. He kind of had to, but I think that becomes a very good political issue for us. And then there's a third category of bills where, I'm just baffled by why he would have vetoed those. They had solid bipartisan support, upwards of 60 votes overall, but not quite that veto-proof majority. And he vetoed some of those, and those were surprising. And those are the ones that were probably most avoidable. So in Virginia, and again, I don't mean to get too off track, but the governor has two options with a bill when it first comes to him. He can veto it or he can amend it. He can make recommendations for amendments. And then if we reject his amendments, then he has a second opportunity to veto the bill. And a lot of his vetoes came after we defeated his amendments. That was a huge lack of communication problem. So, normally, and I chair, again, the public safety committee, I also chair the civil sub. Typically, when we have something that's it's all political, we'll ask, or somebody from the governor's administration will get up and tell us what their position on this bill is. Somebody will say, is there anybody here from the administration? This bill affects the way that state police do their work. Is there anybody here from the governor's administration to speak to the bill? Do you guys have a position? And the answer we got all session long was, you guys do your work, then we'll get the bills and we'll do our part.
Yeah.
Which I guess in a Schoolhouse Rock kind of way makes some sense, but as a practical matter, it's a really inefficient way to do things and doesn't make a lot of sense. And we could have probably collaborated a lot more. They were sort of playing like a poker line. They didn't want to show us their hand and what their concerns were. But it's not a gotcha game, right? It's as lawyers, it's not like on TV, right? There's discovery. Usually, you do want to show all your cards to the other side. And frequently you can then come up and figure out where your friction points are and you can settle things. And just like that, you can do that in a legal context. You can do that in a legislative context too. And this doesn't need to be a showdown. If that's your biggest concern, I can live without that piece of the bill. So, but we didn't have those opportunities. I think we probably could have gotten a lot more done. And the governor wouldn't have had to veto so many bills. And then some of them, look, we knew he wasn't going to sign them. And they didn't, there was no political upside to us sending it to him to veto, right? They didn't fit in one of that categories where we wanted it. We could have just done away with it in the legislature and saved everybody a lot of time and effort.
Yeah, and I appreciate that's super useful information. And a lot of the bills you're talking about, I'm going to ask you about a little bit later if we have time. But the one that I wanted to talk about next is probably one of those where I'm not quite sure, is this a bill that Youngkin you knew was going to veto or not, the suicide bill? And essentially what this bill is, it gets rid of the common law crime of suicide. I will tell you, and I texted you when I saw you putting that up, and I really appreciate it. Unfortunately, and I'm sure a lot of people watching this, unfortunately, have been affected, friends of suicide, family members. My best buddy from high school, unfortunately, committed suicide. I've known lawyers relatively recently that have, and so it is really a personal thing, I think, for a lot of people that it's hard to talk about. Did you expect Youngkin to veto that? I mean, was that a surprise, or was that?
That's another one in those categories where I would have loved to know what his concerns were about it. earlier in the process, right?
Mm.
Because it was not a political bill, right? This is a bill that it came to me from advocates and from families, family members who've had people in their lives die by suicide, and then have had to deal with the legal fallout from that, right? Folks that have had problems making insurance claims, or just dealing with the stigma. We have folks in Virginia Beach area and military folks who, if their death by suicide is closely enough connected to their service, they're considered line of duty deaths, and they are eligible for certain benefits that Virginia doesn't allow because it's the result of a quote unquote criminal act, right?
Okay.
The crime is this common law crime of suicide.
Yeah.
And there were some objections, and there are every year. One of them was really misplaced. There was Tom Garrett got up on the floor and said that I was trying to open the door to assisted suicide because it would have gotten rid of the conspiracy to commit suicide. But there's no crime of conspiracy to commit suicide because it's a misdemeanor, right? It's a common law crime, which makes it a misdemeanor, and there is no conspiracy for misdemeanors, with the exception of, I think, trespass and one other, which we statutorily created that. Anyway, I know I'm getting a little bit in the weeds here. So I knew there was some skepticism that the bill was doing more than what it said it was doing, that it was somehow a gateway to, assisted suicide. And we have a Death with Dignity Act, which I think is probably a good idea, but that wasn't this bill. So I think, it got a little conflated with that in the governor's mind, and that may have had something to do with why he vetoed it. But we had Republican co-patrons on the bill. We had Republican members speaking on the floor in favor of the bill. And so again, if I'd known what the governor's concerns were, I would have been happy to see if there was some language, some protection, some other route, some way we could have, further protect. If he was worried about unintended consequences, there's maybe some language we could have done to deal with that. But he didn't give me that opportunity, and so that's where we are.
Yeah, and just so you know, I'm not shying away from the weeds. That's part of the reason I want to talk. This is anybody that's watching this is either a lawyer or interested about law. So, I did pick up on the argument that hey, this would get rid of discouraging assisted suicide, and you're exactly right. There is no conspiracy or assisted misdemeanor crimes, except if they're specifically statutorily provided. So I didn't buy that argument. So I appreciate you speaking on that. I did, and I didn't really pick up on the argument that if it's service related, there are benefits, but you're saying that there is an exception to that, saying if what they did was a crime, they don't get those benefits. Am I hearing that?
So the Attorney General has an opinion. So particularly, our constitutional, we have some tax relief for family members of veterans who die in the line of duty. You can get a line of duty designation for a death by suicide from the military, but the Attorney General is opining to the Commissioner of the Revenue down at Virginia Beach that those folks still don't qualify because their death was the result of a criminal act. And so they wouldn't qualify for that tax relief here in Virginia. So
let me, and this is
suicide would have fixed that for those.
I've seen a few interesting LEOs coming from this Attorney General that I've openly not been happy with. Do you buy that? Was that an actual formal LEO, or is he just kind of opining to the legislature?
No, there was it was a letter. I don't know if he did it as a formal AG's opinion or if it was just a letter of guidance. I'd have to look back, but anyway, it certainly would have been a beneficial, outcome. I mean, beyond just removing the stigma and the fact that it's just, it's to me, it's a mental health disease outcome as opposed to I'll be treating it that way.
Well, and that's interesting you say that, because I think I read one of your discussions about his veto, and it sounded like he didn't really give any, or you said, in vetoing my bill that abolished common law crime of suicide, the governor failed to articulate any problem. Instead, he noted that we have improved our mental health system, and there's less stigma when it comes to mental illness. Now, maybe I'm misperceiving something, but it seems to me with the world that I deal with on the criminal side, I think Virginia has a lot of challenges when it comes to mental illness, mental health treatment, the availability for care. Can you tell me, my perception is there's not been a whole lot of effort from this administration to fix that. And is it just me being biased and thinking that's all talk? Help me understand what is being done in this administration's effort to help with mental health treatment here in Virginia.
Well, that I would say is probably, I criticize the governor for a lot of things. But that is not necessarily an area where I'd be critical of him. It certainly doesn't go as I would. But he has made an effort. We just did a bunch of Democratic state legislators, and the governor had a big event, I think yesterday or the day before, sort of highlight some of the things we've been doing. And he sort of latched on to an effort that was initiated by Senator Creed Deeds.
Okay.
You recall he lost his son by suicide. And the problem was they tried to check him into a facility, and there were no beds available, and he ended up having to come home and ended up attacking his father and taking his own life. And so since then, there's been a lot of work that's been done. It's called the Deeds Commission, but it's a bipartisan commission, and bicameral work on mental health. And there's an effort afoot to sort of reinvent the community services boards, which is our model for dealing with mental health, to work on our requiring hospitals to set aside more beds for temporary detention orders, to increase mobile crisis response units across the Commonwealth, so that we can respond to more mental health crises with mental health professionals and CSB professionals and social workers versus law enforcement. So we've been supportive of all those efforts. Again, he's sort of maybe a little late to the game, but I don't know, you can blame him because he's a newcomer to everything. But that doesn't it doesn't mean to say that there's no stigma left with suicide, or that we've sort of already checked the box and solved the mental health problem. So this isn't an issue. I didn't think that was a genuine argument for defeating this bill. But I will say, in all fairness, and I hate to do this because I hate being fair to the governor, but this is an issue that he's not been opposed to, and he's been willing to devote resources and political capital to trying to improve mental health.
And I appreciate that. And I am happy to be corrected on something like that, because again, perception, unfortunately, oftentimes is reality. And I liked when I learn information that's useful, and I'm glad to hear that. So again, credit to him, and I appreciate that for what it's worth.
Also orders of magnitude. I mean, to be fair, right? I mean, there's more funding that we would have put in if we were didn't have to deal with the governor's proposed tax cuts and things like that. So as far as, putting your money where your mouth is, sometimes he's certainly willing to sacrifice more robust mental health services if he can give his corporate buddies a tax break. But generally speaking, this is not an issue that he's terrible. So.
Yeah, well, you deal with what you got, and so at least there's some positivity there. Next one, this is really in the weeds, and I appreciate this. HB 1114, where you're taking out contempt of court for folks that are being held in other jurisdictions. How did you even hear about that issue? Who approached you? What made you interested in it?
That was another one where some folks that work with indigent defendants in particular came to me, and I can't remember whether it was Legal Aid Justice Society or, well, again, sometimes the groups then, prior to a legislative session, will meet and they'll work as in concert together, right? They'll form a little alliance of the different groups to find some issues they have common ground on. But this was mostly folks that work with indigent defendants, and we're finding that people were a fairly minor misdemeanor, and then they'd have difficulty getting to court because of a lack of transportation, a lack of ability to get time off of work, a lack of understanding maybe the language, the real significance of showing up on a particular date because of language barriers, things like that. And then they'd end up being charged with a felony for failure to appear when the underlying charge they were charged with was only a misdemeanor to begin with. And then frequently too, they would be unfortunately, some of these folks are frequent flyers, and they'd be charged with a felony failure to appear on a misdemeanor charge when they were incarcerated somewhere else for something else that they had done. So I started out with a much broader bill, right? And the broader bill just says, hey, failure to appear is not going to automatically be a felony, and we wanted to sort of flip the presumption, which is that let's presume right now that they had a good cause for missing it and treat it as issue a summons as opposed to a capias, right? And give them an opportunity to come and explain themselves. And if you don't like their explanation, then maybe you can charge them as opposed to charging them first and having them have to talk their way out of it, which is sort of what the Commonwealth attorneys wanted to do. That got out of the House. The more robust bill got out of the House. In the Senate, they'd already killed an identical version of that bill because they thought it went a little too far. Like everything, right? So there's the question is, I just sort of alluded to this earlier, whether the exception eats the rule or not. And so there was a concern in the Senate. There are those cases where you've got a bad actor who wants to game the system, and they will go into hiding and go to ground and fail to show up until their witnesses are no longer available, until the Commonwealth can't charge the underlying bad case, and then you finally find them, a year, 2 years, 3 years later, and you can't make the case for the underlying felony, but not because they didn't do it, but because they've deliberately allowed so much time to pass. And then at least you had a felony failure to appear to charge them with. I thought that those few cases versus the many cases of folks being unjustly charged, it was a balancing thing. The Senate came down the other side of that equation and trusted the Commonwealth's attorneys not to abuse their discretion on that. So at any rate, what ended up happening with the one piece of it that everybody kind of agreed on, though, was that, hey, wait a second. In those circumstances where the reason you're not in court is because you are a ward of the state, right? You're in the state's custody and loco parentis, I think we used to describe it, right? Where the state's got you. You can't charge somebody with failure to appear for that. And so I narrowed the bill, and that's sort of a lesson in the art of the possible, right? Sometimes legislating is the art of the possible. And so went back, and that was a weird one too, because I'd gotten that out of the House intact, sent it to the Senate where it passed unanimously as a very narrow bill with the support of some Republican criminal law attorneys who got it. Came back to the House. They didn't really trust me that I changed it all that much. And so it was almost a party line vote on the House side. And that made me wonder a little bit about what the governor would do with that, because you could have looked at if you looked at the House vote, I probably was in trouble. If you looked at the Senate vote, which was unanimous, I was okay. It turned out, I guess he looked at the Senate vote on that one, because that one he signed.
Yeah, and look, and like I said, I appreciate it. It's those. Obviously, we would like a more robust bill, of course, but this is at the margins. It has practical. I mean, I've represented clients that are charged with failure to appear, and I'll have to say, look, they're incarcerated in Farmville or whatever, and if the judge is doing their job right, they will usually dismiss it. But the fact the charge comes down the pike in the first place, I mean, so again, those efforts I appreciate. So
apparently, there's a judge out there, and one of the more persuasive things who took the view. He kind of viewed it like, I guess the closest analogy to me is like voluntary intoxication. He's like, it is a willful failure to appear because whatever they did to get themselves locked up was willful, right? And so that whatever willful act they did that got them locked up transferred to their failure to appear. He imputed it there. So, but again, the legislature clearly said, okay, because the other question sometimes is, why do we need this, right? And that was like, sort of like the governor's view to the suicide bill. We don't really need it anymore. There was some question of like, Marcus, why even bring in this part of it? Nobody does that, right? And I started to tell them that story. Like, okay, the judges, if any judge is reading it that way, then yes, let's change the law to make it really explicitly clear.
Well, and also, even if that's the rarity, the charges still come. So it's better if you're, if you. People think that, the average Joe thinks that it's not a big deal, but when you're indigent and you keep getting failure to appear charges and you're already facing 3 other charges, I mean, that matters for your record. It matters for bond conditions, right? Like if you're asking for bond later on and you've got, even if you're not convicted, but charges are seen by a prosecutor, that can change things, especially in those line areas. So
actually, that's funny. That is an argument that came up that is because I think Vaca, even with that, even the narrow bill, they continue to oppose. I think that was one of their grounds for opposing. Is like, well, wait a second, we might need this for bond later. If they have this history of failure to appear won't show up, we won't be able to see those charges from even this. Like, you guys don't need to see that. You guys, if you can't make your case without that bit of information, you're not doing your job right.
And I can't tell you how many times I've spoken to prosecutors and good-hearted prosecutors say, well, he got off on this before, whatever case it is, it's a, assault, DUI, whatever. Well, I saw he was charged, it was dropped. And I'm like, yeah, you shouldn't be considered. Why are we even talking about it? Well, we both know why we're talking about it. Okay. So I appreciate
this
that.
presumption of innocence doesn't necessarily translate, right? Just because he got off doesn't mean he didn't do it, right? In their mind.
Yeah. In fact, he's lucky that he got off, that kind of
Right.
thing. So the next one is, you've referenced this before. This is I think we agree, a political bill, but it's the HB 1539, essentially the extradition for abortion bill. And so you referenced it before. So one of the questions, though, it also prevented essentially the sharing of health information. Talk about that aspect of it, because I think well, you could talk about it from 1,000-foot view, but also hone in on that part of the bill. I want to discuss that.
So my bill had two parts to it, right? Yeah. And it was more of it was a shield bill for abortion providers. And one aspect of it was, hey, we're not going to cooperate on the criminal side with requests for extradition for people charged with crimes, but you also wanted to protect people's information from becoming evidence of a potential crime. So,
and just before we go there, I want to make sure that I understand the facts of the extradition part of it. What the bill says is, if you come to Virginia for women's health care, abortion, whatever it is, you can then not be later extradited to Tennessee because they're making it a crime to go to another state to get treatment. Is that what the bill is?
That's exactly right. Because you can't consider with this crime of leaving your state to come to Virginia. Now, if you're a Virginian, and for better or for worse, right? I mean, because of the way extradition law works, this is not a shield against somebody. Say a doctor goes to Tennessee to provide abortions that are illegal in Tennessee, and then comes back to Virginia, so he's in Bristol, and now Tennessee says, hey, we want them. They broke a law in our state that's against the laws of our state. That's unaffected by this bill, right? And so if you commit the criminal act in the other state, and we need to have that, whether we agree with the other state's laws or not, you need to have that kind of extradition cooperation. This is, this bill would have said, essentially, if you never left Virginia, everything you did was inside of our borders and boundaries. It's a discretionary call. The governor, currently, I think, has discretion to under current law to say no to those types of extradition requests. This would have made it, non-discretionary and say, hey, you won't cooperate with those requests when it has to do with crimes involving women's health and abortion.
And we're talking about both the families that leave the state to come here for treatment, but also the providers here that provide it as well.
Yeah, right. And anybody, and facilitators, right? I mean, there are the states that have specific laws against aiding and abetting leaving the state, right?
Fair.
So if somebody if somebody gets to the Virginia airport and gets in the Uber driver is technically, are they helping them flee the state? Or if somebody gets in an Uber in Tennessee and drives to Virginia, that's a little bit of a tougher case, frankly, because it originated there. But anyway, the people that are fully in Virginia that are facilitating are not aiding and abetting in this, and shouldn't be extradited for that either.
So going on to the data portion, tell us about what that was intended to do, how you foresaw that happening.
Yeah, so I mean, one of the things you've got is you don't want folks, so what this says is we get a separate bill about criminal subpoenas, but this bill just said on you don't necessarily even need a subpoena if you can access from the providers like Google or Facebook or any of these places that track your location data. You can purchase data that will tell you, what enough information to know that somebody's been tracking their menstrual cycle, and then they went to a drugstore, and then they went to a clinic where there's a Planned Parenthood, and they had all these things in a sequence that can help you build a case, right? That the reason they were in Virginia was to seeking abortion services, and you can build that circumstantial evidence by accessing this data about their what they've done. And so this bill would have said that it's a violation of the Virginia Consumer Protection Act for the provider to release that information to anyone for any reason. Because again, sometimes it's not a criminal subpoena. Some of these states Texas has a civil statute on this, right? And they have property
Yeah.
laws and things like that. And so the search warrant piece of it, which the governor did sign, it's a narrow piece of it. This would have said to these folks, you've got to have in your terms and conditions, you've got to have some protection for this consumer data that's stored on these electronic devices. And if you don't, you're liable for violating our Virginia Consumer Protection Act.
You said that Youngkin signed the search warrant portion. Tell me about that.
That's a bill that Barbara Favola and Vivian Watts had in, where we said that Virginia law enforcement agencies can't. I don't know if it's specific to Virginia or not, but you couldn't include women's menstrual health data in a criminal search warrant. So you couldn't say, hey, I know that you have a phone where you track your menstrual cycle on an app, and I need to, I'm suspicious that a crime has been committed where that's relevant evidence of that crime.
Yeah.
So I'm going to get a search warrant for that. The view is the only, again, potential criminal act that has to do with your menstrual cycle would be to figure out whether you were potentially pregnant or not. And so we said that's just not the appropriate subject of a search warrant in Virginia.
Well, it's interesting because I was doing a little bit of research, and my understanding is in 2023, the AG's office sent somebody to argue against a bill similar to that. Did you expect the governor to sign that bill? And was there a discussion about the change in that position? How did that, from your understanding?
That was a surprise. I mean, honestly, that one probably fit more in that category of things we kind of expected he would veto, which would have been bad for policy, but good for politics. I think it was a pleasant surprise that he didn't veto it. I think that was, again, probably a political calculation on his part, because right now, in Virginia, there's very limited use for that kind of information through search warrants anyway. But he got lampooned and really hurt his own reputation nationally because his veto of that bill, or his opposition to that bill, I guess, in the past, had gotten him some unwelcome national attention. So,
okay, well, whatever it takes, I guess.
Yeah.
And by the way, I've still got several questions to talk about. Tell me, your time is the most important thing. So whenever you need to hop off here, just let me know. I appreciate how far you've gone so far. So
sure. Well, no, listen, I probably talked too much. It's my fault. But let's keep going.
No. Next, I was going to turn to the civil side of things, and the next bill, HB 418, class actions. And I will tell you, in order to prepare for this discussion, Christy Kelly, who I think you know well, she's a very good consumer protection attorney here in Virginia. I actually rent space from her. She shared some anecdotes in her world. But tell me about the class action bill that you were trying to push through. What was the purpose? How you envision it working? And then let's talk about kind of the opposition that happened there.
Sure. So this one is one of these. Virginia is an outlier kind of a bill. I think there are only 2 states where you can't you can't certify file a class action lawsuit in the state court, Virginia and Mississippi. So we would have left Mississippi as the last state that doesn't have a state court level form of class action lawsuits. So what this would have done, the bill would have done, is essentially just codified the federal rules, the federal rules of procedure regarding certification of classes. Kind of Virginiaized it a little bit, if that's even but we suited it, with the language and the lingo to fit in Virginia's code, but essentially adopted the federal rules around class actions to allow people and attorneys to identify a class, certify the class with all the same criteria that you've got. So you don't need to learn any new law, figure out different elements that that allow for these things. And the same thing for the compensation of attorneys. All that was based on what's already existing in the federal rules, and allow that to happen in Virginia. And it would help, again, I don't know what the anecdotes that Christy shared, but one of the ones the Southern Poverty Law Center, Virginia Poverty Law Center shared, is the issue of payday lenders, right? We regulate payday lenders. We've tried to regulate them out of existence, frankly, in Virginia. But the penalties for payday lenders are often civil penalties, and frequently there may be $500 or $1,000, or there's some percentage of the amount loaned, and you're taking out these really small, micro, or as a lot of people are concerned. Trying to get an attorney to help you to go sue a payday lender to recover $1,000 or $1,500, even if the attorney's fees can get paid on a one-off case, if they win and you show up and everything, it's a very daunting thing to be able to get representation to actually enforce your rights for those sorts of things. Whereas if this payday lender who's been sitting in town has been ripping off hundreds of consumers over years and years and years to the tune of tens of thousands or hundreds of thousands of dollars in cumulative damages, then maybe you can attorney interested, right? And I can represent all of you folks who are all similarly situated, had suffered the same harm from the same acts, from the same bad actors, then they're much more likely to be able to find somebody to help them recover. And so that's essentially, what we were trying to do. The governor would probably veto it, but honestly, this has been one of those where the plaintiffs bar and the Trial Lawyers Association are sort of on one side. You got there is a defense attorneys bar and the corporate and the Chamber of Commerce types who like Virginia's, what they would call it a balanced legal environment.
Okay. Yeah.
Corporate, right?
Yeah.
So they don't want to upset that. They think it makes us more attractive for businesses, the fact that you have to go to federal court to get your class certified here and pursue a class action. So another example, and I got a little bit in trouble with the folks at Volkswagen. Like, we weren't going to oppose your bill, but now you mentioned us by name. But the suit too, where they offered this big settlement. They actually are headquartered here in Virginia, and you had hundreds of Virginia consumers who got ripped off by this big corporation. And your choices were participate in the big federal settlement that everybody agreed with, or go to a loan in Virginia, which Christy Kelly, I think, did actually very successfully for hundreds of folks. But we could have negotiated a better deal for Virginians. Class actions.
Yeah, and I will tell you, Christy, I was having a hard time, even a lawyer, not every lawyer knows everything, and class actions are kind of this thing you hear about and you see the movies about. And I said to her, like, what's the problem with just going to federal court? Why does it matter? And what she pointed out was, in federal court, you need diversity of jurisdiction. So that means that if you're a Virginia resident and the bad actor is also a Virginia company or a Virginia landlord, you're essentially precluded from class action unless Volkswagen, where I imagine they probably were able to get diversity through some other means, just because it's probably at headquarters everywhere. And what she was talking about is bad landlords. So you have a landlord, for instance, hypothetical, where they rent out to 100 or 1,000 folks, and they're a Virginia company, some investor group, and they're screwing people out of $50 fees. Well, no attorney is going to take that individual case. No attorney is going to take a couple of those cases unless it's just because it's the wrong thing. But from a financial standpoint, you need that class to be able to make it make sense from a litigation standpoint. So, I appreciate that the effort there.
You don't have to go. I mean, sometimes you get diversity by getting at least some members of the class from another state. You have to find somebody from somewhere else. But like you said, a lot of this stuff is a fairly local kind of a problem. So.
Yeah. I did have another question about that. Give me just a second. It's blanking on me. I'll probably come back to it. Let me get a little technical on you. I do PI, and it looked like it ended up being HB 315 Medicaid and liens in PI cases. How did you I love this. So you're essentially putting a time limit on Medicaid to get us responses. Explain what you were addressing there, and then how did you even know about it, and how did you address it?
Yeah, so that's one of the ones that the Virginia Trial Lawyers attorney brought to me.
Yeah.
And apparently it's a huge problem amongst PI attorneys, but most people don't even understand it. And I was trying to get, I worked with Jason Ballard, a Republican from Southwest Virginia, right? So talk about being bipartisan, being from the Southwest part of the state versus Northern Virginia, working on it together. And I kept getting him to try to explain it more, because I don't understand. They go, well, DMAS wasn't releasing their liens. I'm like, what's DMAS? What lien are you talking about? Why does anybody care what that is? And so, it's funny. Sometimes, knowing too much about it can be a problem. But the fact is that in Virginia, right, so if you're injured in a injury case and any part of your medical bills are paid for by Medicaid, which is administered by the Department of Medical Assistance Services, which is DMAS, then they get a lien on any judgment or recovery. So you didn't pay for your health, your medical care, right? The state did. So if you recover for medical bills or medical things, then since DMAS fronted you the money, they want to get paid back out of your settlement, and so they have a statutory lien on your settlement, and you can't pay out the rest of the settlement until you determine exactly how much that lien is. And DMAS, being a government agency with no real profit motive and no interest in being really quick about getting that money out of your attorney trust account, was taking forever. Literally forever. Like cases just never getting resolved, but years to respond to a simple request, which is, how much will it take to satisfy your lien so that I can pay you, the state of Virginia, I can remit this money to you and send the rest of the money to my clients and myself and everybody else who's entitled to a piece of this settlement and or payout. And so what we said is, listen, if you guys, we're going to ask you for the payoff amount, and you've got 60 days to answer. And if you don't answer in 60 days, then we'll calculate it for you. We'll do the work. While our paralegal figure it out, we'll give you the number. And then you have 60 days more to object to that. And if you don't object after that, then we're going to go ahead and assume that number is correct. And we're going to remit you the number we sent you, and we'll close out our case, and everybody gets paid. I think we ended up with a little bit of a compromise. I think we started from 60 to 90, and then the second period is maybe also it went stayed at 60. But we ran into a little bit of a problem near the end with the Attorney General's office. Again, they didn't want DMAS settling any disputed claims without their involvement. They thought that was their job to negotiate that. So, but we ended up resolving that by saying we'll copy the Attorney General's office. So the attorney you have to copy the AG's office on your demand, that second round of demands, when you're saying, hey, we've calculated the number, here it is. To the extent that's a negotiation with DMAS, the Attorney General's office is copied in, and they can be a party to it. If they want to intervene and say, hey, wait a second, you're way lowballing us on this estimate because you're just trying to run out the clock, they can intervene and advocate on behalf of the state. So that's what that bill does. Trial attorneys everywhere love it. I don't even talk about it at my town halls because, my constituents know what that is. I barely know what it means. I just learned it this session.
Yeah, I mean, I will tell you, health insurance and Medicaid, Medicare liens are something in my PI practice that everybody's surprised about from a common sense standpoint. If you're injured in an accident and you get medical bills and you have Medicaid, let's say the bill is $100, Medicaid will pay $30. In the PI case, you will claim the $100 plus pain, suffering, inconvenience, and then you got to pay back that $30 to Medicaid. And what would happen is, as you explained, the attorney, would be sitting there with your $100 plus pain, suffering, and inconvenience. Medicaid's not telling me they are owed $30. So I, as the trial attorney, am sitting with a bunch of money in my trust account, a client yelling at me thinking I'm stealing their money, and all I'm trying to do is get the government paid. I never understood. It seems to me hiring 5 people to speed up getting reimbursed so I can pay you just made sense. So I appreciate you putting it on there, and I imagine they're going to have to hire people to at least I would think they would, so they can get paid easier.
So they've agreed, and we've trying to figure that out too. I mean, they initially came back with one of the ways we kill bills in the legislature is with a fiscal impact statement.
Okay.
They give a fiscal impact statement like $40 million a year or something like that they would have to staff up and create new systems and spend $40 million a year to be able to meet these deadlines. And we helped negotiate that down, and we worked on them. So yes, they need to hire some more people, and yes, it will be of great value to the Commonwealth because of the time value of money. They get paid back a lot faster, a lot sooner. It's certainly well worth the investment to recover this money faster and sooner and have use of it.
That is the part of, people focus on these big issues. This is the part of governments that's so important, getting in the weeds. How do we make a little bit more money? How do we make it more efficient for the government? This is where it gets to. So I appreciate that effort. I'm gonna ask you one last, because I'm already taking about out of your time. Zombie mortgages, and I know you were behind HB 184. Tell me about that. Tell me what you were addressing and how you came to to take it up?
But, it's interesting. This one, sometimes it's a rip from the headlines kind of a thing. This one we kind of got ahead of the headlines. It was interesting. There was a Wall Street Journal article about it, right? So to that extent, it's ripped from the headline. But what a zombie mortgage is suppose you had a house that you bought in 2006 at the height of the market at the time. 2008, the market crashed. 2009, you're struggling to make your payments on a house that is worth far less than what it used to be and is underwater. You owe more on it than it's possibly worth. A lot of people were able to work out deals with the bank that was a win-win for the bank and the homeowner. The bank didn't have to foreclose on an underwater asset and lose their share there. They allowed the buyer to stay in it, continue to make payments, maybe over a longer period of time, maybe at a lower interest rate. But usually what ended up happening was the second mortgage. There was a second mortgage on the property, a home equity line of credit, where sometimes people were taking out these down payment loans or basically borrowing the down payments. There was no down payment. And those folks in the second position agreed to just let it go, right? They weren't going to get anything. First trust funder foreclosed, their lien would be wiped out anyway. And so they would charge off these second mortgages. Well, what happened was the charge off sounds like it's done, right? And there can be no effort. You stop sending bills. They stop asking you to pay. You have no idea that there's anything still out there. And now here we are, 2024. We've seen after the post-pandemic a real rise in home prices because interest rates are up and inventory is down. And so now you have folks that actually bought these charged off mortgages. They bought those loans for pennies on the dollar because they were worthless at the time, right? In fact, less than worthless. They were negative worth because there was just no equity. There's no way to enforce them, but they held on to them for a long time, right? And now they're ready to come back and start collecting and foreclosing because they're like, hey, here's a loan that's a $70,000 loan, and it's now a $600,000 property. And that first trust mortgage that got modified, by the way, was only for $350,000 at the time, and this person's been making payments on it for the last 12 years. And so I've got a house with couple $100,000 in equity. I can foreclose on it, pay off the first mortgage, recover my second mortgage, and have all this money left over. And so you had people trying to foreclose on people's homes and access their equity. And I guess this is the part that we finally got to. The insult on injury of that was, and if you want to stop me from foreclosing on your house, not only do you have to pay back the outstanding balance on the loan, but you have to pay interest and penalties and late fees for all those months and years that you weren't receiving any bills, right? That nobody was telling you owed anything. You thought you were paid off. Nobody was asking for any money. And so what this legislation does, it doesn't say you can't foreclose. It doesn't you can't enforce that underlying loans. Look, it wasn't paid off. And it was never released, and maybe it wasn't explained to you properly, but it is what it is. But what you can't do, which takes a lot of the incentive for people to try and do this, is you can't charge those late fees, you can't charge penalties, you can't charge anything for a period where you never sent a bill to custom. And if you do, there are big penalties for doing that. It's basically chased this industry out of Virginia. I've talked to I got some very unhappy attorneys who weren't following this closely enough. Called me after it passed and was signed into law, saying, "Hey, what are you doing here? We've got clients who made a living at this." I'm like, "Sorry, go make a living in Maryland or somewhere else, but don't do it here." Because again, without that extra lucrative piece of it, what happens is you send the letter saying, "Hey, pay this off, or we'll foreclose on your house," and they will because they'll get back on a payment plan. They'll resume. There's usually a right for reinstatement, and so you can do other things. But if your real goal was to try and steal the house from them, you wouldn't be able to do it here in Virginia. So that one I got bipartisan support. I think what ended up happening, we exempted the Bankers Association and the credit unions. And my trick, by the way, for what it's worth, is whenever a group like that comes and says they want to be exempted from the bill, my condition is like, look, I don't think this applies to you guys. You guys are federally regulated. You send bills. You don't purchase your loans on the secondary market. You actually originate them yourselves. I don't think the bill is going to affect you, and so I don't think you need to be exempt. But if you want to be exempted, just in case, I need you to get up and say you support the bill as amended. And so by being able to get them to come in and say, yes, now that Marcus has agreed to make these changes that we requested, we support the bill. I was able to go and say, hey, this bill now has the support of the Bankers Association and the Credit Unions Association. And so that got us some bipartisan support. And ultimately, and the creditors, the other thing we did is unlike the governor's office, right? We went to the creditors bar and said, what kind of language do you want to see in here? How do you want us to phrase this? Let's work on something, because this is going to pass. Why not make it the best bill for you? Even if you don't like it conceptually, let's make it the best bill for you that it can be. And so we got them, we got them at least to a neutral position. So there's nobody really screaming against it at the end. And so the governor signed it.
Yeah, and for anybody watching this, there's a really interesting podcast, Planet Money, that did a very specific story and told a lady
after our bill passed. That's what I was saying, sort of the reverse rip from the headlines.
Yeah,
like, that's the kind of radio story that inspires people. In fact, I've had some people, send me that podcast saying, we need to do something about that in Virginia. I'm like, good news.
We already did it. Yeah. Well, and what I like about the language in this bill, and what you really got to, is it really focuses on individuals buying these on the secondary market. And so, they come back and they say, well, you in that podcast, it was so interesting. They had somebody advocating for being able to do this. And he says, look, we're investors. We bought these on the secondary market, and we're just trying to get what we're owed. And I'm thinking, well, but you knew what you were doing. You knew you were taking advantage of people, and you knew it was a risk to buy these in the first place. So you also knew that there was a risk that the legislature was going to step in and stop you from stealing people's homes from out underneath them if this turned out good. So I like the process by which, the technical nature that you addressed it. And I just think it's brilliant reaching out to the Bankers Association and things like that. I mean, it's just something that only time teaches you. And so, Mark, I don't want to take up any more time. I do appreciate the years that you've been putting the work in. And, we served on the Redistricting Commission. I'll tell you, having to go to Richmond as a practicing attorney just for, I think ours was like 6 months, a period, maybe a little longer. I don't know how you do it. Guys like you and Scott Servell that are always putting in the work, I just really appreciate it. How do you sleep? Do you ever get time to sleep, or are you just constantly out and about?
It helps to be a high energy person. It helps not to need a ton of sleep. I do catch up, every now and then. I get the bags under my eyes to go to proof it. You got to love it, right? I mean, I tell everybody, look, it's a volunteer. There are plenty of people lined up to take my spot. I mean, fortunately, I haven't had to deal with any primary opponents, but if I step aside, there'd be a dozen people that would love to come in and try and do what I do. So, it's a volunteer job, but you got to be passionate about it. And my motivation is, I've always thought the practice of law was about solving problems and improving the system in the world. And that's what, how I view my legislative work. I mean, this is just another extension of that, and using the law, making sure the law is a tool to repair the religious, my religious upbringing is a Reformed Jew. We talk about tikkun olam a lot, which is repairing the world. But I think the law is to cure injustices and right wrongs and make the world a better place. And so this is how we do it. And so if that's your motivation, then sleep seems less important.
Well, again, I really appreciate the effort you put in. Anybody watching this, give him some cash. He needs it, because as an attorney, I appreciate the effort to make the system better from both a lawyer, but also as a dad, as a person. So really appreciate it, Marcus, and thanks for your time. Okay.
Hey, thanks for having me on. Love to do it. Maybe we'll do it again sometime when we get some of these.
Anytime you want to come and tell me about something, I'm a nerd. I'll talk to you. We'll just record it and put it up.
All right. Sounds good, James.
All right. Take care. Bye.